Well, good morning, everybody. That's the first hurdle over, getting the tech out the way. So hopefully we'll be able to progress through the slideshow without any more difficulties. I have to first of all say I'm delighted to be able to be talking to you today. It's really helpful to be able to engage with such large audiences on such important issues that we all have to deal with from time to time. I want to just talk about the agenda and the things that I'm going to talk about today. Sorry, I've just skipped forward. I want to talk about the informal approach, because I think one of the things that we often miss when we're dealing with disciplinary issues is the opportunity to deal with things at the right level. And when I was looking at the questions beforehand, there were some questions about lessons that I've learned about dealing with discipline and grievance over the years. And this is certainly one of them, that sometimes we jumped too far and too fast into the formal processes when we might have had the opportunity to resolve things at a lower level, which is better all round, really. So I'll talk just briefly about the informal approach. I will focus on workplace investigations and how we establish what we believe has gone on in our workplaces. I'll talk about companionship in hearings. I'll talk about the disciplinary hearings themselves, focusing on some of the issues that might arise out of the particularities and circumstances of the pandemic that we're in. And I'll finish off on appeals. Now, what I've done, I've looked at your questions that you posed beforehand, and I've tried to hopefully address these in the presentation. So I'll address those at the relevant points. And as Rebecca was saying, I will take a pause as we're going through to see if there are any additional questions that come through, as well as we've got a few poll questions that will run throughout the session, just so there's a little bit of interactivity as well. I think the first place to start when we're dealing with any disciplinary matter is think about, well, what are we being measured against? I mean, this session is about managing a fair disciplinary process. And there is an Acas code of practice on handling discipline and grievances. And this sets out clear guidance on what fair looks like when you're handling disciplinary and grievance issues in the workplace. It is a code that is referenced by the Employment Tribunal, so it's an important thing for us all to be aware of. But one of the things that we will always do when we're beginning any discipline and grievance process is look at our own company policies and procedures as well. Now, hopefully, what you've got in your policies and procedures will reflect the principles of fairness as outlined by the Acas Code of Practice. There were a couple of questions that people had asked around, can employers bypass or override Acas in a disciplinary process? And by that, I'm presuming that the questioner was meaning the Acas Code of Practice. So the clear answer to that would be, well, no, because the tribunals will be looking at it. So if you did bypass or override the Acas Code of Practice, you may face consequences at the Employment Tribunal. So it's far better to try and make sure that you follow the Acas Code of Practice. There was questions as well around, does the process change for SMEs who might have limited people involved? Well, the Employment Tribunals do take into account the resources that different sized organisations have at their disposal, but it shouldn't mean that we don't follow the Acas Code of Practice or try and follow it to the best of our ability. Just looking at some of the principles here, I'm just going to quickly run through them. Dealing with issues promptly is an element of fairness, and by that we mean don't wait for things to go wrong. Don't use your disciplinary procedures necessarily to catch people out. So if you see me doing something wrong, one of the principles of fairness is you would tell me as soon as possible to stop doing it that way, so that I have the opportunity to do it in the way that you want. So it's not a case of saying, oh, watch Terry make a mistake, or watch him make another mistake, watch him make another mistake, now we've got him. That wouldn't be a fair process. So promptness means tell me as soon as you're aware about it. Acting consistently. This is often one of the things that many organizations say, how do we know that we're pitching things right? Well, you might have organizational intelligence, you might have policies and procedures which lay out how you will deal with particular things in your organization. So as long as all things are equal, one breach of a rule in one circumstances which achieves a penalty should achieve the same penalty in the subsequent situation. But as we all know, there are people involved in disciplinary processes, and it's often difficult to assess somebody's mitigation or their apology, but you should aim to try and just put all of those things front and center in your decision making so that you can show that you're acting as consistently as you can. You should carry out investigations. Now, the Acas Code of Practice, I'm just going to read you the relevant paragraph from the Acas Code of Practice, because when it talks about investigations, it talks about two things. It says it's important to carry out necessary investigations of potential disciplinary matters without unreasonable delay to establish the facts of the case. In some cases, this will require the holding of an investigatory meeting with the employee before proceeding to any disciplinary hearing. In others, the investigatory stage will be the collation of evidence by the employer for use at any disciplinary hearing. And I think what that's pointing out is sometimes when we think about an investigation, we think that there has to be a full-blown investigation with an investigator appointed, but that's not the case. If it is simply a matter of pulling evidence together to show that something needs some attention is needed to address an issue, then that gathering of the evidence can be the investigation stage. There was a question asked in terms of investigations about should we talk to the employee. I would say that's usually a minimum, because it can be a benchmark for where you go next with the process. The principle of fairness is that you always tell the employee about the problem, and you also allow them to present their case. And this will happen at various levels. It might happen within an investigation, and it may happen within the disciplinary hearing as well. There should be a right to be accompanied in formal disciplinary hearings, and when formal sanctions are applied, there should be a right of appeal. So I hope that when you look at the principles of fairness, there's nothing in here that would, would cause any employer any concerns or worries about the level of achieving fairness within their own workplace. Poll question 1. So Rebecca, will you run the poll on this one?
Can everybody see that poll? Yes.
We're getting some votes coming in.
Wonderful. Unfortunately, as the host of this meeting, I can't actually see how many people have voted. So Terry, if you can comment the poll for me.
Yeah, we're rattling through about 150 odd of 200. So I'll just give it a couple more seconds on this one.
Okay, are you ready for me to end the poll?
Yeah, it's about 170. So if you just give it another couple of seconds, Rebecca.
Wonderful.
So a final call for if you want to cast your vote on this one, everybody. Yeah, you can close the poll now on that one, Rebecca. Okay. Lovely. So I'm so disappointed that people aren't ringing Acas. That's the lowest level one. But never mind. Maybe you're all feeling fairly confident. And I think the issue with this one is it can sometimes be a bit tricky. And I suppose if there was a depends answer on this one, many of you might have gone for the depends one. So I mean, if I just reference the Acas Code of Practice on this one, where it does specifically talk about overlapping grievance and disciplinary cases, and how you deal with them will depend on the way that they overlap with each other. So if an employee raises a grievance during a disciplinary process, the disciplinary process may be temporarily suspended in order to deal with the grievance. Now, the reason that that line comes first, it's almost like, thinking about the principle of fairness, that if you're wanting to act as an employer, but somebody raises a grievance that may be purporting to give some explanation or there's some mitigation, in terms of proceeding with the formal actions, it's seen as fair if you can hold your horses on the action that you want to take before exploring to see whether there's anything in the issues that the individual has raised. However, some of the the issues that might be being raised will maybe interconnected, and that degree of interconnection and relatedness can allow you, and I'll read from the code again, where it says, where the grievance and disciplinary cases are related, it may be appropriate to deal with both issues concurrently. Okay, so it does give a little bit of tolerance for you to decide which way you're going to deal with them. Essentially, what it does is it just requires you just to do a little bit of thinking about the circumstances that you're facing. Okay, I'm going to talk specifically now just about the circumstances that we're in with the restrictions that we're all under in relation to the coronavirus pandemic. The principle is that you should always try and find a safe, fair and reasonable way to go ahead with procedures. But sometimes this isn't possible, and you might need to consider if it might be fair to suspend a procedure. So some of the issues that might make it not possible are tech issues, for example. Do people have access to the technology to be able to engage in remote hearings and the like? If you're wanting to proceed with things face to face, do those things meet existing government guidelines about being able to do that? It's fair to say that COVID-19 has not stopped issues occurring and needing to be dealt with, but neither has it taken away the need for employers to carry out a fair process. What it has changed is what fair might look like in the contents of the pandemic, remote working, social distancing, and the types of issues that are arising. And there was a question in the registration set of questions where somebody said, well, what do we do about the situation where there's a refusal to wear a mask when they need to be working with people in a care situation? And I think it's fair to say that we're starting to see the first of the employment tribunal decisions around mask wearing, and some of the decisions coming from the tribunals are that where employees are unreasonably refusing and an employer does follow a fair process to deal with that situation, then the employer's process is being held up as fair by the tribunals. The trickier situation, of course, is where an employee cannot wear a mask for whatever reason. And the employer is faced with that situation where it can't wait, it's got to do something. And what it needs to do is to think about, are there other ways it could resolve it rather than the wearing of a mask? We've been dealing with COVID for some time now, so organizations have put in place creative ways around things. Can people be delegated to different duties or roles? If all of those things can't be done, rather than going down a conduct issue, because it's not a question of a person refusing to wear a mask, it's that they can't wear a mask, an employer might be looking at a capability and SOSR reason for taking action. But again, each case is going to need to be considered on its merits. I think I'm going to talk a little bit more about remote hearings and the challenges of handling remote hearings when I come to the that section of the presentation. But I'm going to pause there just to see if any of those who were managing the chat have got any specific questions which have come up so far.
Hello, Terry. We've got one about employees who continually delay the meetings and cancelling. What do you
Okay.
do in that case?
Yeah, well, I think this problem's always existed. You know, that people have always seemed to come up with a reason why they cannot participate in a disciplinary process. I think it comes down to what your judgment call is, or what the circumstances of what the reason they're advancing for not participating in that process. And I think the question is it that they are unwilling to attend or unable to attend? So say, for example, you know, an unable reason maybe about their well-being at this particular time, that they're saying they don't feel capable, they don't feel well to be able to participate in the process. And in those circumstances, it might be that the employer might just put a pause and wait until the employee is feeling better and able to participate. But even that, if the person continues to say that they are unable to attend in person, there may be things that the employer can consider around achieving fairness, even with those difficult circumstances. It could be, if you can't attend in person, could you respond to some questions remotely that we would send out to you, and you could send a written submission in order for us to be able to progress with the matter? Because I think the tension that employers are always faced with is doing nothing is not the option either. It doesn't do anybody any good just to have the disciplinary process suspended over somebody indefinitely. So I think there's got to be a judgment call, but a little bit of exploration about what the circumstances are about why they cannot attend.
Wonderful. Thank you, Terry. The only other question that we have at this time is, for example, if you work in an SME and there isn't really that skill in-house to deal with a disciplinary investigation, would it be worth bringing in an HR consultancy?
Yeah, that's absolutely fine. Yeah, to bring in external resource to help you if you don't feel capable of delivering a fair process yourself. I think my experience has been that I would always want to retain the decision-making process in-house. So say, for example, an external consultant might be very good at carrying out the investigation, which might gather all of the relevant evidence for the decision maker to actually conduct the disciplinary hearing. Because I always think the decision is best made by those who are within the business, who know what is needed within that business, because they've got that texture and understanding of the business, and sometimes an external person doesn't quite have that depth of understanding.
Thank you, Terry. And one that's really relevant right now, it's to do with an employee who's been off for a long time and either has or claims to have a long COVID. So it's whether or not the company can rely on occupational health to determine whether or not the person is fit to attend. So whose call is it?
Ultimately, it's going to be the employer's call. Everything else is almost supporting advice, which goes into that decision that the employer will make. So say, for example, you might go to occupational health. They will give you some information about the individual and their ability to either come back to work or participate in processes. You may even get things from an individual's GP, but all of that just goes into the decision-making pot for the employer to decide, do we take action? Do we proceed? How do we proceed? Because ultimately everything falls on the employer. The duty always remains with the employer, but showing that you've taken those things into consideration in making your decision, as well as the other issues that you need to take into consideration, such as the impact on the business about not getting an issue resolved, at least shows that you're trying to make the best of a very difficult situation.
Thanks very much, Terry. We'll close the questions now and continue on with the presentation, and we'll take some more questions a little bit later. Thank you,
Rebecca. I mentioned about the informal approach, and one of the lessons that I'd learnt being that sometimes we miss this, and we miss this at our peril. Essentially, the informal approach is not a soft approach to anything. It's the right approach in the right circumstances. So getting in there early and setting out expectations and correcting when people have been doing things, maybe been doing things for a while, but nobody's actually told them. Using this method can not only stop that problem developing, it can create a good connection between the line manager and the employee. You can have plans, you can have, a plan for how you're going to support the individual, what the individual's going to be doing. That can be written down. Doesn't make it formal. You write down a plan of action, and essentially it maintains relationships between the manager and the individual in a way that sometimes, with the best will in the world, when we carry out formal processes, sometimes they can leave a few scars. So let's not, lose the opportunity to deal with things informally. Of course, some things can't be dealt with informally. The more serious issues, the gross misconduct issues, they require the organisation to respond in a formal way, so that the rules in which you are articulating and taking action, are reinforced, and you show that when you say that there is a rule to not do something, you mean it when there is an allegation that rule has been breached. Looking at our investigations phase, and investigations, I always refer to this as the foundation upon which good decisions are made. Okay, but before I get into just the investigations, usually when an investigation is being carried out, and particularly if an investigator has been appointed separate to the decision maker to carry out the investigation and fact finding, there is a question of whether somebody should be suspended or not. And it was a question that somebody put in the pre-registration chat about, saying sometimes it can feel you're damned if you do, you're damned if you don't. What are the pitfalls of suspension? Now, thinking about suspension, suspension I think should be your final option that you take. You should usually explore all other ways of managing a situation before suspending somebody. And there are some good reasons I say that. When you suspend somebody, you're suspending them on full pay. So you send them away from the workplace and you're paying them. And sometimes that act of suspension, even though it's accompanied by a letter which says this isn't a disciplinary sanction, to the individual it feels like a disciplinary sanction. And then you can sometimes find yourself having to deal with people going to see their GP, being signed off. That then adds delay to the process that you want to carry forward. The other issue is we're all human, and sometimes when people are suspended and let's say the disciplinary investigation and process finds no case to answer, people still have to come back to the workplace, and there's a lot of chatter around, well, what did you get away with? So there's lots of good reasons why you might want to avoid suspending people if you don't have to. Of course, in some situations, you're left with no choice. If you feel that there's a risk to you carrying out a fair process, if you think there's a risk of the repeat of the behaviour which has caused you concern, then you might need to take suspension in those circumstances. But the question is around what's a reasonable investigation. A reasonable investigation is one that acts quickly, will involve talking to the employee to get their side of the story. There may be the need to talk to other witnesses. It's about gathering facts. It's about pulling together documents and records so that it can support the next stage of the process. It's separate from the next stage of the process, and usually that somebody independently does this and then passes all of that to the decision maker, but it's linked. It provides the necessary support for why we do move to the next stage or why we don't move to the next stage. I think we've got a poll. If we can move to that, if you could run the poll, Rebecca.
Can everybody see that?
Yeah, we're getting lots of votes coming in, Rebecca.
Fantastic. Give me a nod, Terry, when you're ready for me to share the results.
Yeah, we're nearly there. Just give it a couple more seconds, Rebecca.
No problem.
Okay, you can close it now, Rebecca. Great, thanks everybody. Yeah, so just on a narrowish when the no vote has it on this one. So I'm being a little bit unfair on some of these questions, because I think those who voted yes, of course, part of the role of the investigator is to gather evidence to support the allegation being investigated. But the reason I put a yes no here was just to raise the debate about that's not the only role. If it's if the sole purpose of the investigator was just to gather evidence, they would almost be acting as the case for the prosecution, and they're not. They're an independent part of the process to look at the allegation and to look at the evidence that either supports or indeed does not support the allegation. So they're going in there genuinely with an open mind to say, right, I've been presented with an allegation. I might have some terms of reference to look into. What does the evidence say? And this is this sense of trying to achieve objectivity, not being biased, not being led. And one of the challenges that we often have is keeping the investigation separate from the decision maker, because usually the decision maker is somebody senior in organizations, and one of the things that they sometimes can inadvertently do is seek to influence what the role of the investigation is. So if you're ever carrying out an investigation, think of yourself as that independent objective sense where you're just trying to gather evidence, and it might be pointing that the allegation is being supported, that there's lots of evidence to show that what is alleged to have happened has happened, but you might also find evidence to the contrary, and it's your job to present both of those things. Okay, moving on. Some of the challenges sometimes is reluctant witnesses, and we do get this a lot at Acas, and we get asked, what do you do if a witness is reluctant to provide evidence in an investigation? And what we usually say is the investigator should explore why an employee is reluctant to give evidence. Try and provide reassurance and resolve any concerns they've got. I don't know if you've ever been involved in an investigation, but whether you're the person who is being investigated or you're just a witness to what's going on, it's usually something that people don't like being involved in. They don't really like to get involved in this because they're a little bit worried about what they might say, not only for the impact on themselves, but on the impact on their colleague. So sometimes they're reluctant from that point of view, but the investigator has a role to try and encourage people to participate and share what they know, because this is this disciplinary process is it's not out there, not necessarily there just to be punishing people. It's so that the organization, the business, can learn from what's gone on in a particular situation and make sure that it doesn't happen in the future. So it can be very, very difficult. Sometimes people come to us and say, well, we'll just anonymize the witness statements, and the courts have been very clear on this, and they've said that it should only be in exceptional circumstances should witness statements be anonymized. Now, the reason behind that is that the courts have recognized it. They know it's difficult for individuals, but mere discomfort on the part of a reluctant employee shouldn't be enough, because what it does is it disadvantages the individual who has been subject to the allegation, because if they don't know who may be saying something, they can't properly answer it or give the context in which that situation might have occurred. So in terms of achieving the balance, try and avoid just giving blanket anonymity to people who are just feeling uncomfortable about the process. Just a word on accompaniment in investigations. You should follow what your company policy says. It's in law, there is no right for somebody to have a companion at an investigation stage, but there are some good reasons why you might want to allow it. For example, it can be a stressful situation, and if you think your employee may struggle to understand what's going on and might not be able to fully contribute, it might be helpful to have somebody who is there as a moral support. There can also be situations where you might consider this under the banner of a reasonable adjustment if somebody has a disability. So again, no legal right. See what your company policy says, but then think about maybe the particular circumstances you're dealing with. Within the investigation, the investigator should explain what the purpose is. It does no harm to send written notification to somebody about an investigation, but also then repeating this in the notes of the investigation meeting, because again, it's demonstrating fairness and transparency to the employee about exactly what this stage of the process is. You should be asking questions, looking for evidence, and noting the responses that you're getting. Sometimes resources are difficult, and if you can't have a note taker with you, it can be quite difficult task as the investigator to be doing all of these things. The only thing I would say in practical terms is slow down if you need to. There's no rush. So if you're doing all of the note taking and all of the questioning, just take your time to make sure that you give due attention to both of those things, and just give yourself the time to reflect and take the notes down that you need to. One of the things we should always seek to do in the investigation is make sure that the employee has been given an opportunity to tell you things from their perspective. So there's one question we should always add at the end, because usually your investigation will have been framed by the questions that you've wanted to ask. Always ask that question at the end: is there anything else that you want to tell me? Because that's a free response for the individual to tell you anything that you've not asked about that they think might be relevant. And in terms of recommendations, these are recommendations, not decisions. The investigator will either make an assessment that there is no action based on the evidence that's been gathered, or that there is some action that may need to be taken, and they may give a pointer as to whether that should be informal or formal. It's then up to the decision maker to decide what to do about that. It's the decision maker who can decide to proceed or not proceed based on the things that they consider from their perspective. Okay, I'm just going to take a quick pause there, Rebecca, just to see if there's any further questions have come in.
Hello, just unmuting myself. Well, you've managed to answer quite a few of the questions, which is fantastic. We had a question before regarding the people in the early stages of their career, if they're not meeting performance expectations, is it possible to skip a few of the disciplinary stages? So just give one written warning before disciplinary.
Yeah, well, I mean, your risks are reduced if somebody's in the early stages of their career with you, because the right to complain about what you've done in terms of unfair dismissal is a qualified right that they have to have been with you for 2 years. So what I would usually say is have a well-managed probationary period. That when people come into your business, part of that probation is not just showing them where everything is, it's about looking at what they promised you at the interview and seeing whether that translates into the reality of what's happening on the job. Are they displaying the skills, knowledge, and attributes that you're looking for in that role? Are they picking up the job at the correct pace and speed? And usually your probation period would give you that opportunity to confirm or not confirm without having to go through warnings and the like. So again, a well-managed probation period might give you that flexibility and scope for acting more quickly.
Thank you, Terry. A quick question on recording investigation meetings.
Mm-hmm. I'm going to cover that in the next section. So hopefully I'll just pick that up then, Rebecca.
And then just one quick question: if you need to invite an employee to an investigatory meeting in writing?
That's usually best practice, yes, because it again it creates an audit trail for you. Strictly speaking, in law, there's no legal duty on you to do so, but I would say it's best practice to do so.
Thank you very much. Thanks, Terry. Back over to you. Thank you.
Thanks, Rebecca. So just moving on, let's just presume then that our investigation has recommended that we do need to do something, and we're considering a disciplinary hearing. Many of the things that we think about have always existed, and we just need to think about some of the particular circumstances of COVID. So if we're going to proceed, we need to call a meeting, and that call a meeting will be a written notification to the individual. So this is the bit that we does need to be in writing. It's certainly reflected in the Acas Code of Practice, or make sure that you call somebody to a formal disciplinary meeting in writing. You can cover lots of things in there as well. You can cover exactly how it's going to be conducted. You can cover the things to do with the right to be accompanied, because if it's a formal hearing, the statutory right is triggered, and I'll talk about that in a moment. You should check your procedure. Always have your procedure, so that if there's any questions being raised by the employee about things that should or have not been done, you have your procedure at hand to refer to. Think about who does what. What are you going to be doing? Do you have a note taker with you? Think about what's going to happen on the other side. Does the employee, are they indicating that they are bringing a companion? Are you clear about what the companion can do and cannot do? So just thinking about those things, make sure that you're going to be ready to deal with all of the things that you need to. And of course, if it's face-to-face, you need to prepare that room, think about it in terms of privacy, and of course, with the current coronavirus restrictions, think about social distancing and sanitization within that room as well. Looking at the issue of remote hearings, and this is where there was quite a few questions at registration, and Rebecca, you've just mentioned one now about recording. If you're doing things remotely, so we've got all of the technology, and indeed we're recording this session for you. The first question is, can you do it? And what are the implications? Well, yes, there's nothing that stops you recording. When you think about recording in normal times, if I can use that phrase, it was always recorded in notes, wasn't it? There was a minute taken, or so there was some form of recording. So the principle of recording is no different. It's just the technology that we're using to record. So can you do it? Yes. How would you do it? Make sure that you're upfront and clear about the fact that you are doing that. Maybe explain to the individual that this is going to be an aid for any note taking. A transcript might be taken afterwards that can be sent out to them for them to add any comments to. The only other additional things that we need to, I think, consider when we're thinking about technology and recording is if you're doing it as the employer, think about kind of say your GDPR duties. So what happens to this recording afterwards? Is it only going to be kept for an amount of time to create a transcript, which will then be kept in the company and organization's ordinary filing systems? If it's going to be kept for longer, how is it going to be kept? Who has access to it? Those kind of things. I think the other things around recording that sometimes people say to me is, well, if we don't want to do it, how do we make sure that they're not doing it? Well, I think the more that you do things remotely, the more difficult that is. If you've got somebody in front of you, you can ask them not to do it. But again, they could still do it if they've switched on their recording device on their phone before they came into a meeting. But being clear to them that you don't want them to record, and you would ask them not to record because you're not giving your permission to be recorded. And then if you do subsequently learn that they have recorded, you might think of that as another issue in itself. But if you think somebody's going to be surreptitiously recording you, saying they're not recording and yet they are, the only thing I would say, make sure that you conduct the hearing in the best possible way, because you'll never learn about that recording if you do everything right, because there'll be nothing on that recording that they can advance to turn around and say, look how unfair you're being. It wouldn't be a good position for them to turn around and say, let me play this recording about how fair the decision maker was being in this hearing. So don't worry too much about it, and just make sure you concentrate on what you need to do in carrying out the hearing. I think practically, sometimes we need to think about the the technology involved and whether people can access it. We need to think about that home environment. Can somebody have a private place where they'll be uninterrupted and be able to participate? How are you going to get the evidence to them? Are you going to post it to them? Are you going to send it electronically? And of course, if they are going to have a companion, how do we make sure that they can have those private conferences that they might need? So it may be a case of setting up private breakout rooms that they can go to, or it may be that there's an agreement that you'll take a pause, they'll dial off and dial back in. So however you do it, you can navigate those things. There was a question in the pre-registration questions around what do we do if somebody won't put their camera on when we're doing it. I think the thing to do is think about what the reason that might be behind that. Is it a situation that they don't want somebody seen into their home for any reasons? So look at the reasons behind that and think, well, what's the consequence to me if I conduct this with the camera off? Do I need the camera on at all? We might prefer it, but does it get in the way of us being able to deliver a fair process? Could you run this poll, Rebecca?
I can, Terry, 1 second. How are we doing for votes, Terry?
Just coming up to 200, so I think you can close that one now. We've got a good spread.
Fantastic. Thank you.
Thanks, Rebecca. Yeah. Oh, everybody's on to me now that I'm being very devious with the way that I write these questions. So, can a family member act as a companion during an employee's disciplinary hearing? Well, yes, if they also qualify under the other reasons why they can be a companion. So, for example, if father and son are working in a workplace together, and the son was being subject to disciplinary proceedings, the father would qualify not by being a father, but by being a work colleague of the individual. No would be correct if somebody is just coming along and turn around and saying, well, I want to come along to my dearest beloved's disciplinary hearing. I've got no connection to the workplace. So no would be correct in those circumstances. And it depends, could be, what is the situation you're facing? Is there a particular reason why you would give any consideration to allowing somebody to attend who was a family member? I know this might be things to do with somebody's mental health and well-being. It might be concerns around their ability to participate fully in the disciplinary hearing. So there can be circumstances where you might go beyond the statutory duty that is on you and allow it. I would just say make sure that you document why you have made decisions in particular cases, because the next time round somebody comes along, those circumstances might not exist, and you, again, going back to the principles of consistency, you might agree it in one circumstances and not agree it in another, as long as you have got a good reason for doing so. And being able to have that organizational memory about why you did something in one case and not in another is a very good position to be. Okay, so right of accompaniment, always follow what it says in your company policy. There is a statutory right, so that is a work colleague or a trade union representative. We need to be clear that the companion's role is qualified. They can be there just to support, but there are some representative duties that they may carry out. So if somebody's not very good at articulating themselves, the companion can play a role in the hearing by submitting an opening statement on behalf of the individual and a closing statement on behalf of that individual, just so that you have something from that individual to put in your decision making. One of the things that they can also do is respond to any views which are expressed. Now, views are almost a decision which is being formed in your mind. So be careful about how you ask questions, the tone in which we ask things, because a companion might react to a view being expressed. You know, views being expressed as surely you knew what you were doing was wrong. The tone of the way that I might ask that is expressing a view that I've already formed in my mind, that you knew what you were doing was wrong and you've got no good reason for what you've done. So just be careful about how we can express things, because a companion might jump in there and say, well, what's the point of this disciplinary hearing? You've already made up your mind. So just take a little bit of care on that. And specifically in relation to the times we're in, if the companion has been furloughed, this wouldn't prevent them coming along as a companion, because they're not doing any work for the company. They're not generating profit for the company here. So it wouldn't be a breach of the coronavirus job retention scheme for them to attend as a companion at a disciplinary hearing.
Terry, can I interject very quickly here? We've
Yeah.
had a question regarding family accompaniment and whether or not the person has to be over the age of 18
to
accompany somebody.
Oh, you mean if the employee who is being subject to the disciplinary is under 18?
No, if the companion is under 18, will that still count if they have a son who's 17, for example, and wants to accompany them?
Yeah, well, if they worked at the same company, then they would qualify as a work colleague, so that'd be fine.
Mm-hmm.
And then again, the threshold of who it might be above that 18 age is, the law's silent on it. You just need to make a decision about who we're being asked to come in and why would we say yes or no in those circumstances. So the age doesn't come into it at all if it's a statutory right. If it's your decision, then you might consider whether you want somebody in who is of a certain age or not of a certain age. But it's not, the law's not set any threshold on age for companionment.
Okay, thank you very much.
Okay. After the meeting, and the clear thing here is after the meeting. So after, you should always have an adjournment. You know, it doesn't have to be a long adjournment, but you should take time to consider, as the decision maker, everything that you've heard. Now, you might have heard nothing in the disciplinary hearing which changed your mind from what you were thinking when you went in. But in terms of showing that you're giving due consideration to anything, this period of pause and this adjournment just demonstrates that you have allowed some space for you to think about things. All things are at your disposal as a decision maker, and don't ever think that just because you've had an investigation, carried out a disciplinary process, that you have to at least come up with some level of a disciplinary warning. You don't. If you think it warrants no formal action, that is absolutely fine, and you might kick it back down to informal procedures to measure this. The other things are just a degree of where you think the penalty should be. So first warnings, final warnings, and dismissal are all at your disposal, depending on the evidence and the offence and allegation that you've looked into. What you're usually thinking about is, well, if it is going to be dismissal, what's my risk in any unfair dismissal claim? Again, we mentioned earlier about 2-year service. So sometimes your thinking is, well, what's my risk? But always think about that there are other things that people might bring forward, such as discrimination claims, which don't have any time limit to them. So always be mindful on, if I'm going to reach a decision to dismiss, I think it is the right one in those circumstances, and I would be able to demonstrate what my thinking was to an external employment tribunal. You might need to think of what's happened in the past in the organisation. You know, have we usually pitched offences at a certain level? There are some organisations that have absolute zero tolerance to things, and it's notorious within an organisation that if it's found that you have breached a rule, then that's it. You know, there would be, you know, no mitigation taken into account in any circumstances, because the rule is so important and essential to the conduct of that business. But you do need to give some mind to any mitigating or aggravating circumstances. Mitigation, is there any kind of excuse or reason that the individual is advancing for why they may have done or not done what they were supposed to do? Or aggravating circumstances, which it might be the conduct of the employee throughout the disciplinary process, not showing any acknowledgement about what they may have done is wrong, leading you to think, well, if I just give them a lower level warning, this problem might happen again. So mitigation and aggravation need to be considered. And then duration of the warning, this is usually where you would refer to your policy, because your policy will lay out what certain warnings are tracked. So first written warning might be 6 months, for example. A final written warning could be 12 months, you know, 18 months, depending on the circumstances. But again, just refer to your policy. Got another poll question, if I could run this one, Rebecca?
Certainly. Here we go.
You can close that poll now, Rebecca. Okay, thanks everybody. Yeah, in the main, the appeal manager doesn't need to rehear the case. Okay, so it's not a second disciplinary hearing unless your policies and procedures say that that's how you conduct appeal hearings. So most of the time it's no. The exceptional cases situation is where the appeal manager thinks that things have been done so poorly at the first stage that rather than just listen to it as a genuine appeal, they feel the need to conduct it as a a rerun of the disciplinary. I think in some cases it's better for them to pass it back down for somebody else to do it, but the appeal manager can carry out that. Almost the principle in law is if you spot something that's wrong, correct it. Yeah, so put it right, and you can do that at the appeal stage. So many appeals have been shown to correct procedural errors which have been spotted further down the line. And the way the appeal manager's done that is they've actually articulated, I am rehearing this case. So be absolutely transparent about what you're doing. Now, I'm just going to quickly run through the last bit on appeals because I'm conscious of time. Appeals are a part of natural justice. They stand your decisions and process up to scrutiny. The way that we usually think about appeals, though, is that the individual should advance what the reason or grounds for that appeal is. So it could be things that the procedure wasn't followed, new evidence has emerged, there was bias in the process. So usually the appeal manager is just listening to the complaint or issue that the individual has. You should have a time limit for appeals. Usually it's 7 to 10 days in most situations. That allows it to be dealt with promptly. Don't let it drag on. And usually it's a different manager, and usually in most cases a senior manager. Some of the things to do with how we might conduct it, again, these echo what we were talking about in terms of running the disciplinary hearing. Think about it, it's got its own momentum, it's a different stage of the process, but that important bottom right circle there, be of an open mind. Don't think that, well, because a decision was taken, you just have to uphold it. You don't. You're listening to what the individual's got to say and deciding whether there's any merit to the grounds for which they are appealing against the decision. I'm going to finish off just with this slide which shows some resources, but one of the things that did come in the questions was somebody said, can you share some horror stories of things that you've heard over the years? Well, I've probably heard quite a few, but one of the ones I remember being asked was somebody asking me, should they give the employee the pre-prepared and signed dismissal letter before or after the disciplinary hearing? So I think in those circumstances we might struggle at a tribunal to show that the disciplinary hearing was a fair and open one. And one lesson people said, one lesson I've learned over the years, I think it's just be open if something has gone wrong in a process. Don't ignore it. Do something about it and put it right. Employment